So with Cardona, who I know you work with as well, so
Yep.
does he have the legal trademark for Internet Champion?
He does.
So if somebody, like, let's say, because I think the idea of an Internet Championship is really cool. Like, I think it's the total new TV title kind of thing. Like,
yes.
I see with Tony Khan and what they got over on AEW Dark and the way they present it, like an Internet Championship would like make sense for their product.
Absolutely. And everything's moving to streaming. Everything's going to be internet based in very short order.
So I think maybe you know where I'm going with this. If Tony or another entity wanted to have their own Internet Championship, would they have to pay Matt to do that now? Or no?
They would need permission in some way. You know, Matt might say, I'm going to come work for you, or he doesn't work for AEW, obviously, but if he were to work for AEW, like, this is my boss, I could hold him over a barrel and ask for money, or I could just let it be, let them do it, give them a license. But in some way, if somebody wanted it to have an Internet Champion as a part of their promotion on the regular basis, yeah. I mean, that's Matt's branding. He owns it.
Dude, these are the kinds of investments that I just don't think wrestlers 15 years ago were even thinking about. I mean, it's amazing to me how quickly the entrepreneurial spirit of independent wrestlers has evolved. I think the only case that I could think of somebody that was maybe a little ahead of this curve was Taz with that FTW championship, really kind of a unicorn there in that ECW locker room, having the forethought to get the trademark for that, and years later look at getting paid by AEW to bring his belt out on TV kind of thing.
I mean, he designed it, he created that himself, and separate from trademarks is copyright. And I think it's, in my head, it's a very untapped and it's been a very ignored area of the wrestling business is designs and copyrights and stuff in belts. How many bootlegs are there? I mean, I've got 2 sitting right over here. So some bootleg belts that are in my office decorating it. But at the time that, the 10 pounds of gold or the big gold or whatever was made, neither the designer, so the Millikens and, Reggie Parks of the world, weren't getting their copyrights registered, or if the company owned it. So it was a contractual thing where it said, yeah, you're the author, Reggie or Dave, but you agree to assign it to me. So we as WCW own it. They weren't protecting it, and they weren't going out and stopping the bootleggers, which they could have. And copyright is, if you do it in a timely fashion, if you file and register in a timely fashion, you can get something called statutory damages. So statutory damages are different from actual damages. Actual damages, it might be, oh, Nick, you did this, you sold 10 belts. What's your profit margin? You got to disgorge your profits. I get all that. Or I'm selling 10 fewer belts because of what you're doing, because it's opportunity loss for me. There's my lost profits. You have to pay that. Well, that can be difficult to prove, right? That what the actual damages are, and you have to go through discovery and find all these things. Well, statutory damages says, hey, judge, I want either actual damages or statutory damages, whichever is bigger, we'll figure out at trial. Well, statutory damages, the judge says, yep, these are infringing. This is a 1-for-1 knockoff. It doesn't have to be exact, but let's say that it is. This is an exact knockoff. There is infringement. Nick, by God, you are a copyright infringer. Now I'm going to tell you what the damages are. And so between $750 and $35,000 per work infringed, plus I'm going to get my attorney's fees. Now, let's say you sold 100, 200 belts. Now we're talking about potential liability of $35,000 per belt. So that's, count all those. That's going to be a lot of ones and fives.
I'm paying in Okada bucks. I hope that's all right.
So it can be very expensive, but you think, how many bootleg belt makers are there out there? There's a lot. And even WWE, to an extent, is selling probably some bootleg belts, right? I don't know that WWE owns the big gold belt copyright. I'd be surprised if they do, because everything was done on a handshake back then, right? It was, I'm going to call up Reggie, I'm going to call up Dave, I'm going to call up whomever, and hey, make me this belt. Make it look like whatever you want to make it look like. Well, that means that Reggie and Dave and the belt makers were the designers. So they owned the copyright. Well, absent some signed contract or agreement where they written transferred the copyright to WCW, which then WWE acquired, they don't own it. The belt maker still owns it. Now, the problem the belt maker has right now is how many decades have those belts been out there? How many decades have people been knocking it off? You get into these equitable defenses in the law that says, this is great, but you can't sit back and do nothing for decades and decades and decades, and then now be heard to complain. you've slept on your rights. You kind of don't have rights in it anymore.
So do you think that as the entrepreneurial spirit of independent wrestlers and wrestlers in general progresses, trademarking your name seems to be like a given, right? Most people seem to understand that once you leave, you should have your name or another name ready to be trademarked.
Yep.
But do you think that the broader copyright situation, like, do you think we'll see more talent creating their own belts, copywriting their look? I mean, are these things that you think that would be beneficial to wrestlers as they grow in their non-WWE life?
I do. You know, there's not a lot of wrestlers that create their own belts. Certainly Matt, for example, is one who has and does. And that GCW belt was chef's kiss. That was what a brilliant troll job. I loved it. But there's not a lot of people that do that, but promotions should, at a minimum, be protecting the copyrights and preventing knockoffs and registering it. Because nowadays the law changed a couple of years ago where it used to be you absolutely have a copyright as soon as you create it. So if I grab a piece of paper and I sketch a smiley face on it and, you know, some other stuff, and I held it up on the camera, that's fixed, right? I've created a work of art, judging what it looks like, notwithstanding. I have a copyright in it. I can't enforce my copyright until I have a registration. That's where the law changed. Your registration used to not be required. You could go to court and say, hey, court, I don't have a registration, but I filed an application and it's pending. And the courts would say, great, we'll move this thing forward. Well, now the federal courts say, no, you have to have the registration in hand before you can sue somebody.